Hi, Mike Brown, auctioneer. Our topic today is essentially, do auctioneers have to pay attention to the Supreme Court of the United States? Sometimes we say the United States Supreme Court, but nonetheless, the court I'll probably reference here forward. And my answer is yes. Now, there's an argument, and I understand that. That's all fine. Every attorney in the United States is entitled to their opinion and as well as their free speech. Some attorneys argue that the Supreme Court and their rulings have no binding effect, I suppose, on state law. So we might have a law in my state of Ohio, let's just say, that says that auctioneers can take bids out of thin air. We don't have that law, but let's just say we did. State law that says auctioneers can take bids from anywhere. They can bid for the seller. They can just take fictitious bids. They can run the bid. They can, take, they can do anything they want. I think we've even talked about that issue. They can do anything they want. We got a state law here in Ohio that says that. No, we don't. So let's say the Supreme Court of the United States, the court, says you cannot, as an auctioneer, take a fictitious bid. Now, the one argument is, well, now hold on. The Supreme Court cannot affect or have a binding effect on any state law. And I've seen that, and I understand that. And there are a bunch of attorneys that agree with that perspective, that in fact, if you back it up a little bit, there's attorneys that think that the Supreme Court of the United States and federal courts cannot essentially create any common law. There's a case that was before the Supreme Court, I believe it was 1938, that said that the federal courts cannot create any general common law, federal common law, general in nature, but could they create, I suppose, some specific common law? It would seem to me they could. There are other attorneys, maybe just as many, I didn't do a thorough count, who say, hold on here, federal courts make common law all the time. They routinely make common law. And can that common law affect local or state law? They say absolutely. In fact, I'll read you I think I have, here's one from, I'll let you Google it. This law professor says, proper understanding of the relationship between the new federal common law and the Erie Doctrine provides indirect but compelling support for the view that it is appropriate to take seriously the doing justice function of the federal courts and to, on occasion, override state rules which interfere with that function. What's that function? Justice. The justice function. He also notes Clearfield Trust Company v. United States and Textile Workers Union of America v. Lincoln Mills warrant the conclusion that in certain cases there is both federal judicial power to adopt federal substantive rules and, in a proper case, to have these rules preempt the operation of conflicting local law. Now, all that, and this paper that I found was, I believe, 69 pages long. I'm going to publish a blog here soon with the details, so you can download, or actually you can click on it and pull it right up on your screen or your phone or whatever. You read all 69 pages if you want. I'm going to take a few of the concluding remarks and put them in the blog just for ease of reading, and of course encourage you to read the whole analysis. But I have found attorneys that say the federal courts, including the Supreme Court of the United States, can indeed create common law. And I found attorneys that say they cannot, they're prohibited from. And I found an attorney who said there was no such thing as federal common law. And I found an attorney who said there's federal common law all the time. And they have the authority, they have an intrinsic right to create common law. A duty, one attorney characterized it, a duty to create common law. Wow. See, we've got, oh gosh, a whole bunch of attorneys here in the United States and Washington, D.C. and the 5 territories. We have an abundance of legal thought. But it may not be as clear as one attorney saying, well, the Supreme Court and this, and there's no binding or effect on state law, when there's other attorneys who say the opposite, essentially. I mean, I don't know. I don't know that there's any way to sort all this out in a way. You see an attorney's opinion. I read a lot of attorneys' opinions. I've been sitting next to attorneys for 10 years, listening to their opinions and commenting about their opinions. An attorney opinion on a law or a rule or a precedent or a similar case or a Supreme Court case or how the courts work. I've been in cases where we've discussed just that. We've discussed Supreme Court cases in, I believe, 3 different cases that I've been involved in. I testified in a case referencing a Supreme Court case. Now, the case wasn't a federal case, it was a state case, but I was talking about the Supreme Court. The judge listened. They didn't strike my comments. They didn't say, well, hold on. The Supreme Court decisions or case law, to the extent there is any, don't apply to state law. Nothing in that courtroom was mentioned about that. We just have to be, I guess, prudent. We see an attorney opinion. Let's do a little research. Let's do a little background. I didn't do this research so much as I had people do this research for me, so that I felt like it was disinterested third parties in the legal field doing my legwork for me. And after 10 years of a blog, I've got some fans in the legal community who say, Mike, I'm glad to help. I'm glad to contribute. So I was glad to have that assistance. So anytime you see an attorney opinion, maybe the take home here today is anytime you see an attorney opinion, you might rightly wonder if there's a difference of opinion out there, if there's a different opinion out there. And oftentimes there is. Mike Brantley, Auctioneer. Pleasure to be with you today. Other videos on the same page, others forthcoming. Have a great day and stay safe.